Chief Justice, members of the court, what we're really here about today is something actually very simple. The EFF submits that over 10 million rand hidden in a couch is as problematic and controversial for a president as benefiting from unlawful upgrades to his residence in northern KwaZulu-Natal. And so, having regard to this court's judgment in EFF 2, the submission is really simple before the court, with all due respect. The first one, and these are the broad overarching submissions we say the court needs to concern itself as we go through the various issues that will be contested between the parties. The first one is this. It's whether or not the reasons offered by the National Assembly when it voted down the independent panel's report withstands legal scrutiny. Now, what has happened in this matter is there have been two bundles of reasons that have been advanced before this court. The first bundle of reasons are those reasons that were given at the time by then Minister of Justice, Minister Lamola, in the House and is recorded in Hansard. That is, can be found at EFF Annexure 6, which runs on to 2 volumes, if I'm not mistaken, and I'll take the court there in due course. And effectively what Minister Lamola's reasons are is that the panel misconstrued the threshold it had to apply. And he, and developed by our learned friends for the ANC in argument, seek to draw this distinction between sufficient information, and prima facie evidence for the purposes of an impeachment motion. And what we will submit to you, and when the court considers this argument, is that insofar as that is a reason as to vote down the report, it's not a legally cognizable reason. And it's not a legally cognizable reason. I see the acting Deputy Chief Justice raises his eyebrows at me. It's not a legally cognizable reason, ADCJ, for this simple fact. And that is that there is binding authority which tells you that prima facie evidence exists on a spectrum, and that the objective to find prima facie evidence for the purpose of a motion is not to subject the initial sifting mechanism done by the panel to the same threshold as actual guilt. It's something lower than that. And to the extent that the panel engaged with sufficient information and prima facie evidence, the panel discharged its responsibility accordingly. And that's why that reason, insofar as that is the principal reason in front of you is concerned, that's no reason at all. There are some reasons which have been introduced, particularly by the President and the ANC in this matter, where they've talked about various things being, which I am loosely going to say, they characterize as the report being fundamentally flawed. They actually use that phrase in their pleadings and in their heads of argument at various points. And the argument, as we understand it, seems to be that never mind the sufficient information versus prima facie evidence issue, which I've already addressed in passing, is that this report was so fundamentally flawed that it had to be voted down because of how nonsensical or misconstrued or misapplied it was. And what we say is that it's trite that those reasons which find their way before this court, not in Mr. Lamola's words when given in the House, but under Mr. Figile Mbalula, the Secretary General of the ANC's answering affidavit filed in this court, that's an ex post facto justification, and that's too little, too late. And in any event, even if those reasons were competently in front of the court, which they aren't, because the court will know that none of the respondents seek a collateral challenge of the report in any way whatsoever, that those reasons cannot be relied on the court to justify the National Assembly's reasons for voting in the way it did at the time that it did so. The second one I'm going to move on to is the issue of declaratory relief. Can I just say this about declaratory relief? Because how the debate has unfolded before the court is in this way. On the one hand, what we say on behalf of the EFF is this is a declaratory application. It's a classic 1721A, 1721B type of application, which this court will know from Rail Action Commuters Group, I beg your pardon, is a flexible remedy that has the ability to apply to a wide variety of situations, including ones where a review may be competent. But just because there might be some overlap between a declarator application and a review application doesn't mean that a litigant is forced necessarily to choose one or the other. And particularly in circumstances here where there's no subsidiarity issue, such as Paja standing in our way, then we say that that distinction is even less cogent in the context of this debate because of the way in which the court has already understood declarator applications to apply. And may I just make this point about declarator applications? The court will know that we rely on the Naptosa judgment, which, if I'm not mistaken, is a full court judgment from the Western Cape High Court. And what the full court there says about this review declarator distinction is it says the following. It says that in matters like this one we would submit, where a record is not necessary, then a declarator can play the role of a review. But what we would submit is the opposite is not true, and that you cannot then magically manifest a review into a declarator. So why I'm saying all of this is because to the extent that our learned friends think that there's some magic in this distinction and that they can non-suit us because we chose a declarator as opposed to a review, we say with all due respect, that's neither here nor there. That distinction is a false one. And to the extent that they advance that, there's no cogent argument which suggests that this somehow falls outside the scope of what a declarator is interested in. The court will very well know from Cordian trading what the two-part test is for a declarator application. The first one is the decision regarding the contest of rights and future and contingent rights. We say we tick that box. And then the second leg is whether or not the court should grant the remedy in its discretion. We say we tick that box as well for the reasons that exist on the papers. So insofar as this argument is overly emphatic about the modality is concerned, modality of declarator versus review, we say that that's really not the end of the debate. In fact, it's not the true debate at all. And to the extent that the debate needs to be answered, the answer is that this is perfectly competent for a declarator application to do. Let me then go to my next topic in oral argument. And perhaps what is an appropriate thing to say to the court now is that as I'm developing my oral argument, I'm obviously emphasizing some issues over others. That's not to say I abandon any of my written submissions, and when the floodgates open for the court to ask questions, I will obviously have to defend everything that's on paper, not just what I said in my oral argument. But let's just talk about the rules, because this speaks to the lawfulness of the decision. It's an important thing that I need to clarify for the court right at the very outset, because what the respondents variously do is they overemphasize the case against us. What they say we're asking this court to do is we're asking this court to sit as the impeachment body, and we're inviting the court to make findings that will make its judgment equivalent to the impeachment body. That's absolutely not what we're doing. The National Assembly, in terms of Section 89 of the Constitution, is the body that will ultimately impeach the president. That is not contentious, and the EFF is not asking for anything different. Instead, what we have to bear in mind is, following on from EFF 2, the National Assembly chose to create a mechanism that gave expression to its accountability obligation. And there are three levels to that rule. The first one is the referral of the complaint to the independent panel, and the independent panel doesn't have an open discretion to consider oral evidence and the like. It only considers written evidence. And when it considers the written evidence, it answers only one question. Is there a prima facie case to answer? Now, why that's relevant is because before you can go to the second level of the National Assembly's rule, which is a referral to the impeachment committee, the National Assembly itself has not retained some kind of overarching discretion that allows it to engage the panel's report beyond the content of the panel's report. And indeed, what we would suggest is that the ANC in particular, and the president's attempts to sneak in what we will call traditional review grounds into their answering affidavit to try and evidence how bad this report was, violates or misunderstands and therefore violates the role to be played by the National Assembly at the point of when prima facie evidence is considered. because the National Assembly, by electing to adopt that rule, fettered its otherwise very wide discretion to do whatever it wanted to, and limited itself only to consider whether there is prima facie evidence or there isn't prima facie evidence. So all the other reasons that are in front of you in terms of the rule are incompetent reasons, because they're not reasons at all. And to the extent that the only reason in front of the court is this alleged distinction between sufficient and prima facie, we say is no reason at all for the reasons I've already given you. So to the extent we are now in the world of questioning whether or not the National Assembly has given effect to its obligation or hasn't given effect to its obligation, that's what the court must bear in mind. At the preliminary stage of the investigation, all the National Assembly is asked to do is to vote yea or nay, does prima facie evidence exist? And we say that for the reason that the National Assembly chose. They chose the wrong reason, and the consequence is that the vote to vote down the panel's report is an unlawful outcome because of the misapplication. And can I just say, whilst I'm on this subject and noting the time ticks quite quickly, this is not something new. Some of the members of the court may be familiar with the DA versus SABC litigation in the time of the public protector, before this court confirmed that the public protector's reports are binding. You will remember that in the High Court in that matter, Justice Schippers, when he was in the High Court, effectively said that a recipient of a public protector's report would be entitled to depart from it if they had rational or reasonable grounds to do so. So in Justice Schippers' construction, there is no binding effect, and the repository or the recipient of the report could depart from that if they had other rational or reasonable grounds to do so. In English law, those are called the Wednesbury rules, which comes from the judgment of Bradley in the Court of Appeal. That being said, though, what the SCA did is the SCA said, no, that's not how public law works in our constitutional dispensation. The repository of public power is only entitled to do what the enabling instrument tells them to do. So on the specifics of that case, the SCA overturned Justice Schippers and said the public protector's report is binding, you have to effect it. But critically, if you want to depart from the public protector's report, you have to review it and set it aside. And that's what applies here. It's not open to the National Assembly to look at the panel's report, which says there is prima facie evidence, there's a case to answer, and for the National Assembly in its wisdom to say, oh, well, you didn't meet your mandate, you didn't follow your mandate, you didn't have oral evidence, you considered hearsay evidence, and all those kinds of reasons to rubbish the report. In circumstances where the reasons to rubbish those report misidentify what the panel was entitled to do at the time it did it, and consequently what the National Assembly was entitled to do when it received the panel's report. And so we would say that what we're asking for in this matter here is nothing too dissimilar from what the court has already done in matters like DA versus SABC, and understanding the interplay between a repository of public power and what they can and cannot do vis-a-vis the enabling statute. Can we just also say this then, regarding the rule and the reasons and what has come through? What we would just identify for the court is the following, and it's an interesting debate that has opened up between the EFF and the ANC, surprise, surprise. But the interesting debate is about what is the role of politics and political instruction in the context of the debate. Now, I have to answer this in a bifurcated way, because you'll remember at the time the vote was taken on the floor of the House, politics didn't have a role to play. It was only the sufficient information versus prima facie issue, which I've dealt with already. But what we know in terms of the ANC's answering affidavit is there's a myriad of averments made about how the ANC internally consulted, how they took legal opinions, how that legal opinion told them that there were various flaws in the rule, that they should stop the investigation pending the outcome of other investigations, and so on. And those were all from a political basis, because you'll remember they also say President Ramaphosa recused himself from the NEC discussion, the NWC discussion, and all those other discussions. Well, that's all fine and well. The short point is this. is that if there is a space in which the ANC's arguments that political instruction in a matter like this is permissible, then the ANC is confronted by what this court said in UDM, and that is that in an instance of a clash between an individual MP's political allegiance to their party and their constitutional obligation in terms of their oath of office, it is their oath that must succeed. And we'll say on the application of that UDM principle to these facts, not only has the ANC told you that they took the reasons that they did for political reasons, which is in conflict with UDM, it's also that to the extent that the ANC then relies on those reasons have already been found to be unlawful, having regard to what the court has said in EFF 2 and the potential of political abuse under the abuse of a numerical majority. So we would say that when the court comes to consider this question and reads UDM and EFF 2 together, that is what fundamentally undermines the argument that the reason and the conclusion reached is a justifiable one. And to the list of authorities, UDM as well as EFF2, we'd also add the two other parliament cases about the rules and numerical abuse, which is Mazibuko and Oriani Ambrosini, which this court is aware of. The principle that was vindicated in both of those matters is that where rights of MPs are subject to the will of the majority, the potential outcome is an unlawful one because the majority can rely on its numerical strength to undermine the role to be played by MPs. In Mazibuko, it was about the tabling of the motion of no confidence. In Oriani Ambrosini, it was about how a private member's bill comes out of committee onto the floor of the House. And the court there was emphatic that where those internal rules of Parliament seek to undermine the role to be played by MPs and Parliament itself, in terms of the Constitution, those rules are to be regarded with a high degree of skepticism because they threaten unlawfulness. And we say that that logic applies here in these proceedings. May I just refer the court to two sources of authority. The first one is that even though the Rule 129 at various points interchangeably uses sufficient information and prima facie evidence, we would say that that interchange is not objectionable. And the reason it's not objectionable is because of the Magwakwa authority that we've referred the court to. If the court has our heads of argument to hand, it's at internal page 31, para 114, of the EFF heads of argument, which says there are varying degrees of prima facie evidence. It can consist of incomplete evidence, for example, a single piece of circumstantial evidence. On the other hand, it may be strong prima facie evidence. Prima facie evidence at its weakest is sufficient evidence to institute a prosecution. So to the extent that there's this distinction between sufficient information and prima facie evidence, we say that it's not a distinction because these things exist on a spectrum. And to the extent that that argument is pushed at, we say, well, the Magwakwa authority is the fullest of answers. Can I also say this regarding the role of politics and political reasons that were involved in decision-making? Now, there's some dispute regarding Minister Mantashe and his capacity as the ANC chairman, and did he threaten or didn't he threaten, and is the EFF being speculative about these things, and if so, can the court have any regard to that? All we'll say on this subject is we're doing no more than what Justice Moseneke, apologies, and Justice Cameron said at paragraph 234 of their Glenister judgment, where they said sometimes the harm that can be accrued in rule of law harms is too little too late to be vindicated by means of judicial review. And instead, what is the appropriate course of conduct is by a litigant insisting that the structure that is in place is lawful ab initio, because the correct lawful structure acts as a fettering mechanism on the abuse of an overly wide discretion, particularly where political reasons may be relied upon. And so we say, even if, as a matter of evidence, this question about what Mr. Mantashe said or didn't say is an issue in front of the court doesn't have to go that far, because you've already got the authority from Glenister, which tells you that it's the structure that counts more, or often counts more than anything else. So we'd say that to the extent that political reasons are on the table, that's the answer to there. Which leads me on to the next subject, which is the need for the amendment. And with less than 3 minutes to spare. The need for the amendment we deal with on the papers. I'm not going to advance that at any given length. The short point about the need for the amendment is this. If Parliament is given an unfettered discretion in the way that it currently is, then cases like this, which we say are deserving cases, will be voted down. And either it will be voted down for spurious reasons, the distinction issue which I've dealt with already, or political reasons, which we learnt about through the ANC's affidavit. And unless that discretion is therefore constrained, and you know that in terms of the relief we seek two alternative amendment relief. It's either that the first stage becomes automatic, so in other words, where a panel says prima facie a case box ticked, then that must automatically go to the committee, and the committee decides innocence or guilt. Or we say that Parliament must go and amend the rule to include factors, because those factors will then appropriately fetter the discretion that Parliament brings to bear when it makes this decision. So that's the amendment, really, in a nutshell. And then, if I may just talk about remedy in the last few minutes that I have remaining, the court will know that there are, again, two alternative effective pieces of relief that we seek in the context of this report, resolution, and decision. The one, which is perhaps the slightly more controversial one, is the substitution relief. And there, the argument against us, I see Justice Matopo is smiling, where the argument against us is that this is an unlawful breach of the separation of powers. We say that that's not correct. All the court is doing is it's using the same kind of substitution parameters that exist in other matters where the court substitutes in order to reach that particular outcome. But of course, if the court is not minded then to grant the substitution relief because of the separation of powers concern, which we say with respect is no concern at all, then we ask that the matter be referred for a de novo decision. And insofar as there might be any alleged problem with both of those issues are concerned, we've already addressed that on the papers to say that when the decision like that is set aside, the status quo ex ante is what is restored, which means that the 7th Parliament is as good as a position to determine the motion as the 6th one, because it's not the identity of the decision maker that matters, it's the decision maker themselves being in the same position to make that determination. And then lastly, on the issue of costs, we ask Biowatch. Chief Justice, those are my submissions.